Herzlich willkommen zur 20. Ausgabe von Rechtsgespräch, dem Podcast über Innovationen im Rechtsmarkt und Zugang zum Recht. Am Mikrofon Kurt Brückmann. Meine Gäste heute nach einer kleinen Sommerpause Diana Miles und Rissa Revin. Diana Miles ist die Hauptgeschäftsführerin der Law Society of Ontario. Diana berichtet über die Einführung einer Regulatory Sandbox in Ontario. Das wird eine Erprobungszone vor allem für Legal Tech-Unternehmen. Meine zweite Rechtsgesprächspartnerin ist Rissa Revin. Sie ist Rechtsanwältin in Toronto und hat bis vor kurzem das Geschäft der DAS-Rechtsschutzversicherung in Kanada geführt. Auch mit meinem Lesetipp bleiben wir in Kanada. Ich empfehle Self-Regulating Professions, Past, Present, Future. Das ist ein Aufsatz der Soziologin Tracey L. der im Journal of Professions and Organization erschienen ist. Dass dies eine sozusagen kanadische Folge geworden ist, war gar nicht geplant. Die Gespräche machen aber deutlich, dass sich der Blick in dieses Land wirklich lohnt, weil wir eine Menge für das Nachdenken über die Zukunft des Rechtsmarkts in Deutschland lernen können. Wie immer, helft diesen Podcast unter den vielen Angeboten noch sichtbarer zu machen. Das könnt ihr tun, indem ihr den Rechtsgespräch-Podcast abonniert und ihm eine 5-Sterne-Bewertung in der Apple Podcast-App gebt. Bevor wir einsteigen, kommt jetzt ein Hinweis auf den Sponsor dieses Podcasts, Juris, das Rechtsportal. Juris, das Rechtsportal, bietet als führender Anbieter digitaler Rechtsinformationen umfassenden Zugriff auf juristische Fachliteratur, Gesetze und aktuelle Entscheidungen. Mit Juris arbeiten Sie stets aktuell, rechtssicher und effizient. Jetzt informieren und gratis testen. Unter juris.de. Das war Werbung. Nun freue ich mich wieder auf einen Gast, die Anwältin ist und Hauptgeschäftsführerin der Law Society of Ontario. Die Law Societies in Kanada sind von ihrer Funktion her ganz gut mit den deutschen Anwaltskammern zu vergleichen. Anwältinnen und Anwälte sind Pflichtmitglieder und ihre Aufgabe fassen sie unter dem Begriff Self-Regulation zusammen, wobei Regulation nach unserem deutschen öffentlich-rechtlichen Verständnis Selbstverwaltung umfasst und noch ein bisschen weitergeht, was die Autonomie der Rechtsetzung angeht. Im Unterschied zu deutschen Kammern ist der Föderalismus in Kanada stärker ausgeprägt. Die Law Societies erleben gerade eine spannende Zeit zwischen Bewahrung regionaler Besonderheiten und dem Druck von innen und außen, Berufs- und Verfahrensrecht landesweit zu harmonisieren. Ein weiterer Unterschied: Kammern in Kanada betonen deutlicher als die deutschen Kammern, dass sie dem Public Interest verpflichtet sind und nicht primär den Interessen der von ihnen verwalteten Rechtsanwältinnen und Rechtsanwälte, während also in Deutschland Anwaltskammern und Anwaltsvereine eher Schnittmengen von Aufgaben haben, in denen manchmal ein guter und manchmal ein nicht besonders konstruktiver Wettbewerb herrscht, ist die Aufgabentrennung in Kanada klarer. Im Sinne eines dualen Systems, in dem sich Kammern und Vereine wirklich ergänzen, ein bisschen so wie Paul Möllerop und ich das in Rechtsgespräch Folge 18 auch für Dänemark herausgearbeitet haben. Diese Einleitung scheint mir wichtig zu sein, um zu verstehen, Law Societies in Kanada sind vom Selbstverständnis her eher öffentlich-rechtliche, dem Gemeinwohl, dem Public Interest verpflichtete Verwaltungskörperschaften als Interessenvertretungen. Und mein Gast führt also die Geschäfte der Law Society of Ontario. Das ist die älteste Law Society in Nordamerika, gegründet schon Ende des 18. Jahrhunderts, also etwa 100 Jahre vor den deutschen Kammern. Heute hat sie etwa 50.000 Mitglieder mit Anwaltszulassung und etwa 8.000, die als Paralegals mit Teilrechtsberatungsbefugnissen ausgestattet tätig sind. Ich habe sie zu einem Rechtsgespräch eingeladen, weil ich gelesen habe, nach einigen US-Bundesstaaten und manchen Ländern in Europa und darüber hinaus will nun auch die Law Society in Ontario Regulatory Sandboxes, also Reallabore einführen. Diana Miles, welcome to the Rechtsgespräch-Podcast.
Thank you, Cord. I'm delighted to be here.
I apologize for the long German language introduction, but I thought it might be good for my listeners to understand the role of law societies in comparison to German mandatory bars. But now I want to get to our topic right away. A few weeks ago, I read that you consider establishing a regulatory sandbox for the legal market in Ontario. What is a regulatory sandbox in your understanding?
We're, as a regulator, we're really focused, Cord, on making sure that we are open to ensuring that our regulation is proportionate. So we want to make sure that in Ontario, legal services providers, technological or others, are able to actually develop offerings for those in need of legal services so that it's more accessible, it's less costly, it's more efficient. The sandbox is something that we're putting together on a pilot project, which will allow different deliveries of innovative technological services by either individuals or enterprises who wouldn't normally be regulated by us. So perhaps they're not a licensee, they're not a lawyer or a paralegal, perhaps they're an organization, and they have either a business to business or a business to consumer technological legal service that they'd like to actually test out and want to be able to offer, even though they don't fall within our regulatory framework. So this allows them a safe place to come in with us to actually test out a new model of legal services provision with some criteria that we're going to provide to them. And we will see if they are able to provide and meet our regulatory requirements. And if so, at the end of the testing cycle, when they've shown us that their service is proportionate to what we're trying to achieve, is safe, is not going to harm clients in any way, then they may be given an opportunity to be accredited to be a legal services provider moving forward, even though they wouldn't normally be in our framework. It's a way for us as a regulator to actually reduce our reach while still protecting clients and allowing the market to open up.
What do you mean when you say reducing the reach?
We want to make sure as a regulator that we're not overburdening licensees or others. We don't want to be closing all the doors to allowing them to provide legal services because we have a lot of needs of consumers that are not being met right now, and quite a bit of data over the years that we've collected in Ontario that shows us that there are many, many gaps in the legal services provision market that could be filled by innovative services.
So if I'm not mistaken, Ontario already allows multidisciplinary partnerships.
That's correct.
So what could happen and which kind of legal providers are you aiming for right now with the sandbox?
So we really are highly focused on those who want to provide technologically adept services. So there will be lots of other models, but we are going to focus on technology-enabled services. It could be individuals. It could be groups of individuals. What we're assuming is that there will be perhaps some law firms who would like to have a go at a new type of service provision that they'd like to provide where they might use other than lawyers or paralegals to help provide that service. It could be that it's other enterprises that are non-legal, other companies who have an innovative opportunity to provide something that is a legal service, but of course, if they were to provide it outside of our regulatory framework, they would be exercising unauthorized practice, and we would, in the normal course, shut them down. This gives them a place to come in and try that, even though they may not be lawyers and paralegals.
Diana, when you talk about technology-driven legal service providers, in Germany, we quite often look at the United States, at the West Coast, at the thriving legal technology scene. Do you have your own technology scene in Canada?
Sure. In fact, Canada is very well known for its technological legal services adoption. We have many, many providers. A few months ago, I saw a list of the legal services providers that are out there right now just in Ontario, and it's a massive list, and it keeps growing every day, which is one of the reasons why as the Law Society, we have to take a very close look at these opportunities and ask ourselves if they are in any way going to be harmful to the consumer, to make sure that we can ensure that it's regulated. Many of these service providers will say on their websites or in their disclaimers that, of course, they're not providing legal services. They're just providing information. Our goal is to try and bridge that gap to allow a service provider to be really innovative, to permit that access to legal services and not have to say they need a disclaimer, because we do have so many just general regular consumers who are out there self-represented or simply can't find a legal services provider to help them with their needs.
Diana, it's my understanding that a regulatory sandbox mainly serves two purposes. First, as you said, to allow innovative business models, or I should say business models that kind of don't fit easily into the existing regulatory framework. But secondly, regulatory sandboxes also allow regulators to rethink and refine their regulatory rules because developments in the market and regulation are kind of interdependent. Is that true for your sandbox as well? Do you think you need to rethink your regulation also and test it in the sandbox? Or is that not part of your sandbox?
No, I think fundamentally what we understood when we were talking about developing a sandbox was the fact that we did need to take a rethink of our regulation as we move forward. Mm-hmm. But we wanted to make sure we were doing it incrementally and that we actually understood the services that were going to be provided. We absolutely believe that hopefully we'll get lots of opportunities to have people into the sandbox. And then once we see that these services are acceptable and they're actually providing great access, we will have to look at our regulation and start to adapt that regulation to make sure that we're changing our standards and our bylaws and our requirements to allow those services to continue to do their work. So we do think that this will prompt quite a significant change in the way we approach who and what we regulate as we go forward.
Diana, could you tell us a bit about where you are right now?
Sure. So we approved the sandbox in April of this year. So it took us a little bit of time to get to the point where we were comfortable with what we were going to do and how we were going to approach it. So it's now just being implemented operationally. We expect that we'll start to have our policies and we'll start to reach out to entrepreneurs probably in the latter part of this fall to see if they'd like to come into the sandbox. It has been approved as a 5-year pilot project rather than a permanent program because we do want to test it and see if it's going to produce what we're hoping it will produce. And then once it does, we'll make a decision as to whether or not it'll continue as a regular program. But for now, it's a 5-year pilot.
Okay. Diana, who or what triggered this sandbox?
I would say a bit of a combination, but mostly it's the legal profession itself. What we're already seeing just within legal services providers is that they are themselves developing technological legal services. That's great. They're legal service providers, so we're not as concerned because they can provide you with legal advice. But what we're seeing in Ontario and Canada, because we've got a very active technology sector, were a lot of different non-lawyer, non-paralegal service providers creating programs already where they were providing legal information. I would say, Cord, the other prompt for us was really what we were seeing in other countries as well with their development. So the United States is well known for a number of legal services provision units, Zoom, other things that are going on out there that, Rocket Hub, where it's already happening. And just being north of a large country where it's already happening means we better get on that train as well and figure out what we're going to do with it. So it's a combination. Certainly academia is very focused on this. We have a lot of innovation hubs that are active across the country in different universities where they're testing out similar ideas and similar business concepts in their hubs. So I think the timing was just right. And we don't want to be too behind as a regulator, so we want to get out there and make sure that we're part of it.
What were the reactions of the various stakeholders? Let's maybe start with the profession, with the lawyers in Ontario.
I think it's a bit split. Most legal professionals are really pleased to see that their regulator would be looking proactively to expand the opportunities for consumers. But there are, those in the profession who feel that it may impinge upon their ability to practice. So if we're allowing non-lawyers and non-paralegals to come into the sandbox with an innovative technological legal service and then granting them regulatory authority to be able to do their work, there will be some professionals who will always, be concerned about those businesses taking business away from them. So there's a little bit of that in the profession. But of course, as a regulator, we act in the public interest. And one of our primary principles of considering all of our work is to ensure that we're facilitating access to justice. And that's paramount in our minds. So, I think it will play out. The reality, Cord, in our environment is that we have so many areas of the law where consumers are self-representing or simply just don't want to use lawyers and paralegals due to cost reasons. We have family law in Ontario where well over 70% of the participants in the family law area are self-representing and can't seem to find the assistance they need. So we have to, as a regulator, step up and fill some of those gaps so those individuals can get informed information and will not be harmed by the information that they're getting.
When you talk about consumers, potential clients of legal service providers, are they somehow involved in the project of the Sandbox? Have you managed to get their voice heard in the regulatory discussion for legal service providers?
We actually do focus groups and other discussions with self-represented litigants and just the general consumer and the members of the public, give us their thoughts on lawyers and paralegals as well as the services that are being provided. We did a significant civil legal needs review in Ontario a little more than a decade ago, which showed us a lot.
Which was received in Germany, actually.
Yeah, it was huge. And, it was very eye-opening. And we've continued to do focus groups since then to make sure that we're keeping our eye on the pulse of those changes. And the self-represented situation is just getting worse, not better. And, that's in Ontario where we're not that large as a province. We've got just under 15 million consumers or members of the public. We have, as you noted earlier in your introduction, between paralegals and lawyers, we have well over 60,000 individuals who are in our framework. Yet we have so many consumers who aren't able to obtain legal advice. So, as is the case in all countries, we're all struggling with how to support that access and opportunity.
If I may count the legislator to be a stakeholder too, I would like to know what's the position of your provincial legislator towards your work. I know that, and we know that in some countries, those regulatory sandboxes were installed by governments, that regulation was kind of forcefully changed by governments or by parliaments. How would you describe the discussion between the legislator, which, if I'm not mistaken, is always the provincial legislator, and not the federal legislator, and your law society?
It is the provincial. And, it's very positive. Our Ministry of the Attorney General is the unit that we would look at here in Ontario. They're very positive about change. Of course, especially because we're being proactive about opening the doors and trying to do that expansion and add more accessibility. So I think that's a very positive thing for us. It can only be positive for them because it's going in the direction that they'd like to see. Yeah. So I think those discussions have been very good. As you noted in your opening, Cord, we are not restricted because we're a self-regulatory organization. We have our own legislated mandate, and we were able to simply change our bylaws in order to permit this to happen. So we've got quite a bit of flexibility because our regulatory framework is very strong and we have control over how we apply it. But it's absolutely critical and paramount that we apply it in the public interest. And the ministry is always looking to make sure that's what we're doing. So I think they're pleased with this approach because it does open new doors for everyone. My last question regarding stakeholders would be interesting from a German language speaking country perspective. In our countries, we have a very strong system and a tradition of legal expenses insurances. 40% of all German households have a legal expenses insurance. Accidentally, in this episode of the podcast, I will talk to Rissa Revin, who was with DAS Canada, and I will ask her a bit about the role of legal expenses insurances. I understand that this is not a part of the culture to obtain a legal expenses insurance in Canada, is it? No, it's not. That has never really taken hold in Canada. It's been the subject of a number of discussions over the years, but we do not have legal expense insurance here.
And that makes access to justice quite costly, right?
It does, yeah. So we have a legal aid system here, where if you have a certain threshold of income, which is quite low, you can apply for legal aid and it'll be supported by the province. But because that threshold income is so low, it doesn't capture a lot of people. So there is a middle income gap in the individuals who are being able to access that as well. So we continue to have a low end and a high end gap. In the middle, it's very, very hard to support.
You said that you will do a 5-year regulatory sandbox. What is your and the Law Society's vision? How should the legal market change in your view?
I think at the end of the 5-year pilot, for it to be a success, I'd hope that what we will have seen is that a number of different entrepreneurs, groups, or businesses would have come to us, would have joined our sandbox, and after a couple of years, we would have actually authorized them to continue providing their services because they're safe and they provide great access and great legal service and information. That would be a success for us. I don't think it would take too many for others to realize that it's something that they need to start to adapt to as well. I think in the future, what we're going to see, and I'd hope we would see as both a regulator and as both just a population, is that people are more open to actually understanding that legal services can be provided in different ways, and that as long as the regulator has indicated that it's a safe option, we'll be able to take advantage of those options. So what we don't want to see at the end of this, and we're hoping to curtail that, are a lot of different technological services out there who may be providing information that's going to be of harm to individuals, or where they're going to lose money, or they're going to lose their personal data or their privacy or anything like that. So we want to be very careful about that. So a success story is we've produced quite a few innovative technological legal services groups who are providing great service to consumers who really need it, really need that help.
Diana Miles, thanks very much for this inspiring conversation.
Thanks, Cord. I really appreciate being asked to join you today.
Dieses Rechtsgespräch führe ich mit einer Rechtsanwältin, die Spezialistin für Versicherungsrecht ist. Das ist interessant, wäre aber nicht Grund genug dafür, dass ich sie in diesen Podcast eingeladen habe. Mein Gast kommt aus Kanada und war, bevor sie sich wieder einer Kanzlei in Toronto angeschlossen hat, Geschäftsführerin der DAS-Rechtsschutzversicherung. Allerdings nicht der DAS Deutschland, sondern der DAS Kanada, ein Land, in dem es Rechtsschutzversicherungen nach unserem Verständnis noch vor 10 Jahren gar nicht wirklich gab. Mich interessiert, welche Rolle Rechtsschutzversicherungen beim Zugang zum Recht haben können. Welcome, Rissa Revin. Thank you for agreeing to accept my invitation to this episode of the Rechtsgespräch-Podcast.
Thank you so much, Cord. I'm so happy to be here.
Rissa, I told my listeners in the German language introduction that you were part of the legal expense insurance industry's project kind of to establish a market in Canada. So although the DAS, which in German means Deutsche Automobilschutz-Aktiengesellschaft, was established in Berlin, my city, almost 100 years ago, in Canada this was kind of a start-up endeavor, wasn't it?
It really was. You know, one of the things that it's hard for people to understand about Canada is the duality of our British background with an overlay in respect of law from the US. You can't help that osmosis over the border. It kind of seeps in. So we have a very interesting legal market. Mm-hmm. And when it comes to people's rights and claims, there's very much this ownership. It's mine. And there's also, it's quite litigious. People don't mind suing. So having this idea that there be an insurer in the midst, that you could get an insurer engaged, is both fascinating in the sense that it would mean money and an ability to pay, but it interferes with that ownership principle. So it took a bit really for people to understand that it's still their matter, even when an insurer gets engaged. And that's been really an interesting learning experience as far as trying to appreciate how we should move that forward.
How would you, from the Canadian perspective, describe legal expense insurances? Is it the main aim of the DAS and other legal expense insurers to finance lawyers' fees, or are legal expense insurers actors in the legal market, giving legal services themselves?
It's a bit of a blend, but mostly the first. So what happens is an individual has a matter, and it is really very much serving this part of the population that for years really didn't fit in anywhere. So they had enough funds that they weren't part of the support scheme from the government, but really paying for legal costs is really expensive, particularly in our market. So it's a combined. So there's something called before the event insurance, which is very much in a normal insurance policy, as your readers, as your listeners, would appreciate. And that is funding. And there's a lawyer's engaged. They get the advice from the lawyers. But still, there's a role for DAS in that as far as being the funder in the matter.
Mm-hmm.
And then there's something called ATE, after the event insurance, which is really much more in the hands of a lawyer and his or her client. Mm-hmm. And it's really about paying for it after the fact.
Just for our listeners to understand, in Germany is probably the country with most legal expense insurers. Over 20 million legal expense insurance contracts in Germany. More than 50% of the households actually have one. They process more than 4 million cases annually, and legal expense insurances pay out around 3 billion euros, which is quite a substantive amount of money. Those numbers are according to the GDV, which is the umbrella organization of insurance companies in Germany. At the beginning of the podcast, I said in Canada, it is my understanding that you kind of started with legal expenses insurances. When was that?
It was 2010. So it was a predecessor. I was not yet with DAS. Mm-hmm. It was 2010. So we're pretty much in our 11th year, or it's in its 11th year now. Mm. And we already did have, and Lloyd's was in the market though. So there was some legal expenses offered from Lloyd's. And there were, I think, some other international players who were offering it through some domestic participants. But from an overall perspective of this is our brand, this is our offering, 2010 was really when it started. And quickly, DAS began to lead the market because that was its sole driver. Yeah. And it really, it was a bit of a sway. It would go up and then it would kind of drop off, and then it would go up and it would kind of drop off. Mm. And while no one wants to benefit from the pandemic, that's not a desire for anyone. But what we really saw as the pandemic began, that's when people understood. The light bulb went on, and people understood when you're in a difficult situation, as everyone has been in the pandemic. And we call it LEI, but legal expenses insurance. Mm-hmm. That's when you need it. You need it when your funds are limited. You need it when you started a business and you no longer have that business and you have a landlord coming to you for payment. You need it when you have to deal with your employees in a really difficult situation and you don't have the funds really to deal with it. So the pandemic really shone this light on the product. And I would say that since the beginning of 2020, I don't know if uptake has really been much larger, but certainly interest really increased. Right. Because it was no longer just this discussion about the need. The need became very real to a lot of people.
I understand this perspective of the customers. What about the legal profession in Canada? When legal expense insurances came and started, were lawyers happy about the rising number of insurances? Did they perceive you as kind of opponents in the market? How was the collaboration or the discussion with the legal profession?
I think, it's funny, Cord, because we have a very significant insurance market in Canada. Mm-hmm. It's small as the country is, but it's a very significant insurance market, and we have a very significant legal market. Mm-hmm. So the two have worked together closely for a very long time. So it was more, what is this, as opposed to opposition, right? And then I think they saw the value. They saw that there would be insurance to pay for bills that maybe wouldn't have gotten paid in any other way. And so our partnership has been fantastic. Certainly while I was with DAS, I felt a very strong bond with our panel counsel. We had a very organized, very responsive panel counsel team. They very much believed in the product. They saw it beneficial for their clients and themselves. Their voice has been very powerful to move it along, and no opposition really that I've ever come across.
I find that very interesting because in Germany, and of course I'm trying to compare our two jurisdictions and the two markets with each other. In Germany, as I said, legal expenses insurances are very important for the legal market, and still there is some kind of antagonism, I would say, with lawyers sometimes feeling threatened maybe by the fact that very powerful insurances are very interested in the liberalization of the legal market. When we talk about legal technology, sometimes insurance companies might want to offer services themselves, and this looks like a threat. And it's very interesting to hear that in a rather new market in Canada, this is not the case.
Well, here's why, and I think there's a very fundamental difference. We have a law society rule that makes it quite difficult to set up a law firm. Mm-hmm. So in order for a legal insurer to create their own legal team and sort of basically cut out the need for lawyers, it's quite a developed, intricate, expensive, difficult process. So we didn't go that route. We didn't have our own legal team.
So no DAS Canada legal team, like the law firm in England and Wales where DAS actually had their own law firm.
Correct. So first of all, we were so small, it probably didn't make a lot of sense anyways in the size of the entity, but the hoops you have to go through to create your own law firm in that context are quite significant. You need breadth, you need size, you need a big amount of premium. Without that, we weren't a threat. There was no threat aspect.
What are the main risks that you insure? You mentioned tenant-landlord issues. What are the main risks for legal expenses insurances in Canada to be insured?
While I was with DAS, employment, I would say, was a very significant risk to be covered. It's those sort of basic contractual. That's where the rental agreements fall in within a broader scheme of agreements. Auto, so any kind of auto kind of claims. Not the personal injury stuff necessarily, except for ATE, but the regular kind of things that can go with auto and sort of very specific business elements. So licensing requirements for trucking, for example. We have a lot of trucking companies given the US-Canada border. So there's a lot of different regulatory elements that go with that. And if you're offside them, you can lose your license. So there are very specific coverages for that kind of element. And then we also had partners who were digitized and home insurance, it would be wrapped into home insurance. So elements of that would cover anything the home insurance didn't cover would add a cover of that. And that's been very lucrative and helpful for our client base as well.
Okay. So are most of the clients of the legal expense insurance industry consumers, or is it rather companies who actually take out those insurance contracts?
Largely, it's, it's switched. At the earlier days, I would say it was much more personal.
Yeah.
Now, really what we've found in a market like ours that has 36 million people across the second largest landmass in the world, we're spread out. And so what we can't do really is sell a one-off legal expense policy. So that was the start. Didn't really work all that well. So the driver has always been volume. And we sell it through associations, through consolidations of people that the brokers put together. It's very much driven by a volume business, which means now it very much has a tie to either some kind of a joint enterprise, like an association, or a business.
Now, you worked for a company with a base in Germany. So I'm curious, did you actually look at the German and Western European insurance market? And is there anything that you found particularly interesting about the legal expense insurances in Europe, in Germany and Austria?
Well, and clearly for me, it was all about the size. When you're dealing with a small book of business as we were, I was incredibly jealous about the size of my colleagues' businesses abroad and what that meant they could do. So including creating their own legal team, absolutely. And the breadth of history. So we often pulled data and experience from our colleagues, in the UK and in Germany and in Belgium, because it gave us a much better understanding of where we could go as opposed to our small extraction of data in our small business in a small country.
Yeah.
So, it was really that I think they gave us a lot of insight into how the product can grow and also helpfully where it didn't work. So it was an opportunity to see where efforts were made that didn't pan out and why they didn't pan out. And we got to avoid some of those things, which was very helpful.
I am going to ask a question, and I think I already know the answer. We learned a few weeks ago that the Law Society of Ontario is thinking about establishing something which is called regulatory sandboxes to loosen regulation of the legal market, which is very strict in Canada as it is in Germany. Do legal expenses insurances have a position on this kind of trend that we see worldwide of liberalization and deregulation of the legal market? Do you prefer a strict and regulated market, or do you prefer a more liberalized market?
It's so, I've been practicing for 30 years, Cord, and I've grown up in this very regulated market. And then you add insurance, working in-house in insurance which is highly regulated. So it's what I'm used to.
Yeah.
So two things. I think the market as a whole really does need to loosen that whole idea about how hard it is to establish a law firm within another organization. That really does, I think, need to loosen. I'm hopeful LEI would play a role. I can tell you that we had lots of discussions with the Law Society about uses for LEI and really emphasizing the joinder between us, which is access to justice.
Right.
So I'm hopeful that that will be part of the examination, but I have no inkling really, given that it's a new announcement. I have really no inkling as to how they're going to go, but I would hope we'll get some play in there.
When we talk about access to justice, what would you describe as the main obstacles to access to justice in Canada?
Cost. Absolutely cost.
Clear answer.
Yeah. Well, let me step back too. I think, it's really funny. I've been, as I say, in the legal field for 30 years. Most of that time was either in a practice with a law firm, so I had a very distinct view, or with or many companies that could well afford legal advice, and it was never an issue. I have to say that until I joined DAS, I had no real vision of how important, how significant the access to justice issue is in Canada. And then I would add, given that I'm now part of my profile is diversity and very important to me, there are access issues related to that as well. Related to linked to community aspects, linked to how communities feel about legal advice and really ensuring that message is spread out in a much broader way will help the system.
A few episodes ago, I think it was episode 9 of this podcast, I spoke to Shannon Salter of the British Columbia Civil Resolution Tribunal. Do legal expenses insurances take notice of those low threshold tools and institutions at all? Or do those institutions like the Civil Resolution Tribunal kind of fly under the radar of insurance companies?
I think it's about stacking the benefit of all those opportunities in a market like ours where if you're unable to afford legal services, you've got to find a different way to get them. So I think her work is astounding. And there's others like her in other parts of the country as well. So again, because we're so regionalized in respect of the offering of legal services, I think they go hand in hand. And I can say that as when I was leading DAS, we very much tried to partner with organizations who are really trying to move that needle forward so that sort of in addition to their efforts, we would then be the next level of assistance. Because there really is this striation, these breaks between the offerings. So those that are really trying to bring it to those really in need, that's where I would put those services. And then small business owners, and particularly in this really current difficult time, not being able to afford legal services, we kind of jump in at that level if they have the insurance. And then, of course, you would stack on top of that the more expensive services thereafter. So for me, I think the answer to the problem is everyone being involved in those processes, because then you get the full stream of offering for anybody depending on where they may be in that system.
So Rissa, your professional journey took you to very different parts of the legal industry. And so I guess you are one of the few people who really have seen the market from different perspectives. Let me ask you a last question. If a law student asked you, should I go into the management of an insurance corporation or so with my legal skills, or should I become a private practitioner? What would your professional advice for this student be?
Well, I think firstly, it really depends what she or he would like to do, he or they would like to do. But I can share this. We have this thing called articling in Canada.
We call this Referendariat in Germany. It's a necessary step between law school and becoming admitted to the profession.
Exactly. Yeah. So we're again exactly on the same page there between Canada and Germany. So I articled in a firm and then I practiced for 5 years. And then I went in-house for 25 and now I'm back in a firm. And I would say, try to start in a law firm because the law firm will give you the breadth of what legal options are. You get to see all different kinds of aspects of the practice, which everyone knows you don't see fully in law school. Then, if you really fall in love with something, or you don't love the whole client aspect of it in the sense of generation and billing, I loved my time in-house. And I really loved that I became specialized in a particular field, known for that field, really comfortable in that field, but it was broad enough that it took me to so many different places, as you noted. And I learned so much about the practice from a very practical aspect. What does the client want? We don't want frills. We want answers and we want it done. And now bringing that back again to practice has been really helpful because I can say, look, from the client perspective, we should be doing X, Y, Z. So I do think starting in a firm is really a great way to start when you first come out of law school and then follow your heart because it's a long practice generally, and changing around, learning from it, developing different things is how I've sort of kept moving. That's one of the reasons I'm still here. I'm still in the game is because there's so much to learn. But the foundation absolutely for me was being in a law firm to begin with.
Rissa Revin, thank you very much for your insights from a country which is very far away, but which has quite a lot of common issues with our own country in Germany. Thank you so much for your perspective. It was a pleasure to talk to you.
Same here. Thank you so much. And again, I really love what you're doing here with this podcast. I think it's great to explore all these elements of the law. Appreciate it.
Am Ende dieser Folge steht der Lesetipp. Ich empfehle wieder einen Aufsatz. Self-Regulating Professions Past, Present, Future. Die Autorin Tracey L. ist Professorin für Soziologie und beschäftigt sich mit Berufen, die wir in Deutschland verkammerte freie Berufe nennen. Dem Aufsatz von Tracey L. veröffentlicht im Journal of Professions and Organization, merkt man nicht an, dass er schon 2016 erschienen ist. Er liest sich immer noch sehr aktuell. Die Autorin beschreibt die Entwicklung der Self-Regulation vor allem des Anwalts- und des Arztberufs in Großbritannien, den USA und Kanada. Und sie konzentriert sich dabei auf die Trends, die seit den 1960er Jahren zu Veränderungen führten. Tracey beginnt mit einem Verweis darauf, dass die soziologische Forschung Self-Regulation heute wohl als gescheitertes Experiment ansieht. Dafür macht sie 5 Gründe aus. Einmal hätten viele Beispiele für berufliches Fehlverhalten, das die Berufsgruppen selbst mit ihren eigenen Regeln und Durchsetzungsmechanismen schlicht nicht in den Griff bekämen, dazu geführt, dass der Staat Regulierungsaufgaben von den Berufsgruppen weggenommen habe. Der zweite Grund liege in neoliberaler Politik. Diese habe einen wettbewerbsrechtlichen Blick auf Professionen und ihre Selbstverwaltungsregeln geworfen und festgestellt, dass die Berufsregeln Wettbewerbshemmnisse darstellten und sie daher liberalisiert. Drittens, Globalisierung und Selbstverwaltung passten nicht zusammen. Das Konzept einer Selbstverwaltungskörperschaft gehe historisch und irgendwie auch heute noch von einem Selbstverständnis aus, dass eine kleine, überschaubare Gruppe von Mitgliedern reguliert werden solle. Regionale Regeln und globales Wirtschaften würde insbesondere in den Beratungsberufen mit ihren überörtlichen und internationalen Kanzleien nicht zusammenpassen. Viertens, New Public Management. Das sei wertfrei die Weiterentwicklung von öffentlich-rechtlicher Governance, bei der traditionelle Selbstverwaltung keine besondere Rolle mehr spiele. Und fünftens würden Verbraucherrechtsbewegungen in Frage stellen, ob Selbstverwaltung wirklich so ausgestaltet werden könne, dass Allgemeinwohl und KundInnenbedürfnisse optimal berücksichtigt würden. Der erste Teil des recht umfangreichen Aufsatzes beschreibt die Entstehung von Self-Regulation aus unterschiedlichen sozialwissenschaftlichen Perspektiven. Einerseits aus der Denkschule von Max Weber, die betont, wie Professionen sich Unabhängigkeit durch Selbstverwaltung vom Staat abgetrotzt hätten. Und andererseits aus der Foucault'schen Theorie, die die aktive Rolle des Staats an der Schaffung von selbstverwalteten Professionen in den Blick rückt. Nach dieser Denkrichtung habe der Staat ein Interesse an selbstverwalteten Professionen, um sich selbst durch mittelbare Staatsverwaltung zu stärken. Die Wahrheit liegt sicher irgendwo zwischen diesen Polen. Tracey stellt in der Folge die wichtigsten Modelle der Self-Regulation dar, wie sie in Großbritannien, den USA und Kanada existieren. Stichworte sind regional oder national, echte Vorbehaltsaufgaben, Quasi-Monopol oder nur Titelschutz für Kammermitglieder, Grad der Laienbeteiligung an Regulierungsaufgaben und Trennung von Regulierungsaufgaben und Interessenvertretung. Was für eine Juristin oder einen Juristen noch interessant wäre, für die Autorin aber keine besondere Bedeutung zu haben scheint, wäre die Frage, in welchem Maße Self-Regulators eine echte, originäre Autonomie haben, wenn es darum geht, Berufsregeln zu schaffen, beziehungsweise inwiefern die Leitplanken, nach unserem deutschen verfassungs- und verwaltungsrechtlichen Verständnis wären das die Regeln, die in die grundgesetzlich geschützte Berufsfreiheit der Berufsangehörigen eingreifen, vom demokratisch legitimierten parlamentarischen Gesetzgeber gesetzt werden müssen. Spannend ist zu sehen, wie die eingangs genannten Gründe für den Rückgang der Self-Regulation in allen Ländern und über unterschiedliche Berufe hinweg schon seit den 1960er Jahren eine Rolle spielten. Während es in den 60er Jahren noch primär soziale Bewegungen waren, die den Zunftcharakter von Berufsorganisationen und den fehlenden Zugang zum Beruf für viele Menschen kritisierten, waren es später eher Verbraucherschutzargumente, die nicht den Berufszugang, sondern die Versorgung der Bevölkerung in den Blick nahmen. Und seit den 1990er Jahren kamen hinzu die Globalisierung des Wirtschaftslebens und insgesamt höhere Ansprüche an Qualitätssicherung und Risikomanagement, die auch an Ärzte oder Anwältinnen und andere Risikoberufe gestellt wurden. Zuletzt seien es aber wohl wieder die größeren Skandale gewesen, die zum Misstrauen gegenüber der Self-Regulation führten. Die Autorin erwähnt die hohen sozialen und ökonomischen Kosten dieser Skandale, die stärker wiegten als die Vorteile der Selbstverwaltung, allerdings ohne diese Kosten zu beziffern. Über die politischen Konsequenzen aus Skandalen wie Cum-Ex habe ich in Folge 18 mit Irene Ovonji-Odida vom UNO-Fakti-Panel gesprochen und in der nächsten Folge wird es Dirk Uwer sein, mit dem ich mich darüber unterhalte. Tracey Adams stellt im Folgeabschnitt Details zu den Änderungen der Self-Regulation dar. In Großbritannien sei die Self-Regulation eigentlich ganz abgeschafft worden, für die Anwaltschaft seit 2007 und für den Arztberuf ein Jahr später. Beide Berufe würden mittlerweile staatlich reguliert von unabhängigen Behörden und Körperschaften, in denen die Berufsangehörigen keine Mehrheit mehr in den Gremien hätten. In den USA entwickelten sich gerade neue Organisationen für Qualitäts- und Wettbewerbssicherung, zum Teil beliehene private Organisationen, die versuchten im US-Föderalismus Checks and Balances zwischen den Interessen der Berufsangehörigen und den Patientinnen und Mandanten herzustellen. Ich kann ergänzen, dass die Anwaltskammern und Verbände schon seit mindestens 20 Jahren in den USA dabei sind, ihre Rolle neu zu definieren. Vor allem, weil Wissenschaft und Politik belegen, dass die bisherige Regulierung nicht geeignet ist, den Zugang zum Recht systemisch zu verbessern. Ganz anders Kanada. Dort habe, so Tracey Adams, sich ein recht starkes Maß an Self-Regulation erhalten. Tracey Adams beschreibt richtigerweise, dass das vor allem daran liege, dass in Kanada die Self-Regulators entschieden hätten, Veränderungen selbst zu gestalten, anstelle sich dagegen zu sperren. Ich würde sagen, das trifft zumindest auf die vergangenen 10 bis 20 Jahre zu. Und das Beispiel der Regulatory Sandbox in Ontario, über das ich mit Diana Miles sprach, bestätigt das ja auch. Die Autorin schließt mit dem kritischen Hinweis, dass in der Diskussion um die Abschaffung der Self-Regulation zu wenig Augenmerk auf eine Analyse der Alternativen dazu gelegt worden sei. Ich halte diese Kritik für richtig, denn in der Tat kann es nicht genügen zu sagen, Berufsregulierung geht letztlich auf den Staat zurück. Und wenn die Berufsangehörigen sich nicht ordentlich selbst regulieren, macht's halt der Staat, der ja auch andere Märkte gut reguliert. Insofern ist es eine Stärke des Aufsatzes, dass er die Leserin und den Leser eigentlich unausgesprochen dazu zwingt, sich über die Ratio von Berufsregulierung Gedanken zu machen. Wer Interesse an dem Aufsatz hat, möge wissen, er will eher Ideen von Akteurinnen und Stakeholdern und ihre Wirkung im Diskurs darstellen, als messbare Fakten. Daher kann man ihm auch nicht vorwerfen, Beobachtungen zu wenig empirisch zu unterlegen. Und als Beitrag zu Regulierungsmodellen ist er wirklich instruktiv. Eine kleine Kritik, was einen Juristen möglicherweise auch außerhalb des deutschen Rechts ein wenig irritieren könnte, ist die zu kurz gekommene Auseinandersetzung mit der Bedeutung von Berufsregulierung zum Schutz der Berufsangehörigen und ihrer Patienten und Mandantinnen vor dem Staat. Das Thema wird nur ganz am Ende sehr knapp berührt. Aber das kann ja durchaus auch an den Berufsangehörigen und ihren Organisationen liegen, die in den Jahrzehnten, die der Aufsatz beleuchtet, vielleicht nicht ausreichend belegt haben, welche positive Rolle sie für den Zugang zum Recht oder zur medizinischen Versorgung haben können. Insofern ist letzterer Punkt eigentlich keine Kritik am Aufsatz, sondern eher eine Aufforderung an uns selbst und unsere Organisationen, diese Rolle nicht nur in Sonntagsreden zu behaupten, sondern auch auszufüllen. Unterm Strich empfehle ich die Lektüre, weil Tracey Adams mit ihrem Aufsatz deutlich macht, was wir in Deutschland als spezifische Entwicklung des Berufsrechts und des Anwaltsmarkts beschreiben, hat sich im Ausland, auch im angloamerikanischen Common-Law-Rechtskreis, ebenfalls so oder ähnlich abgespielt. Manchmal sogar früher als bei uns. Und genauso gilt, es lohnt sich auch, den Blick über die Regulierung des Anwaltsberufs auch auf andere Berufe zu werfen, mit dem Ziel, nicht nur die Besonderheiten der eigenen Regulierung zu erkennen, sondern auch Gemeinsamkeiten. Das fällt einer außenstehenden Soziologin vermutlich einfacher als uns, aber es kann sich auch für uns lohnen. Self-Regulating Professions, Past, Present, Future ist im Journal of Professions and Organization erschienen. Der Download von der Website des Oxford University Press Verlags kostet 27 €. Und nun, nach dem Lesetipp, weise ich noch einmal auf den Sponsor dieses Podcasts hin, Juris, das Rechtsportal. Juris Prelex. Die digitale Gesetzgebungsbibliothek ermöglicht es Ihnen, den gesamten Entstehungsprozess von Gesetzen und Verordnungen intuitiv und komfortabel zu verfolgen. Juris Prelex informiert Sie automatisch über sich abzeichnende Rechtsänderungen. Jetzt informieren und gratis testen unter juris.de/prelex. Das war Werbung. Das war Ausgabe 20 des Rechtsgespräch-Podcasts mit Kurt Brückmann. In Ausgabe 21 spreche ich mit Stefan Breidenbach, Juraprofessor, Mediator und Legal Tech-Pionier. Wir unterhalten uns über sein Engagement für eine NGO, die sich zum Ziel gesetzt hat, einen Entwurf für Gesetzesänderungen zu erarbeiten, mit denen die Pariser Klimaziele erreicht werden können. Und ich spreche mit Dirk Uwer, Partner einer großen Anwaltskanzlei, Berufsrechtler und Kammervorstandsmitglied. Ich möchte von ihm wissen, wie die Selbstverwaltung in Deutschland sinnvollerweise mit dem Misstrauen umgehen soll, das schwarze Schafe im Beruf säen und das zu Forderungen führt, Selbstverwaltung durch staatliche Regulierung abzulösen. Wie immer freue ich mich über Ihre und eure Kommentare. Wenn euch diese Folge des Rechtsgespräch-Podcasts gefallen hat, dann gebt dem Rechtsgespräch eine 5-Sterne-Bewertung in der Apple Podcast-App. Bis zum nächsten Mal.